Rather than seeking a fair and balanced approach to tribal sovereignty and workers' rights, this bill simply eliminates workers' rights and protections. This bill would strip hundreds of thousands of workers employed at any enterprise owned and operated by an Indian tribe and located on tribal lands, including casinos, mines, hotels, and construction companies, of their rights to organize and engage in concerted activity and bargain collectively under the National Labor Relations Act. And I'd note, Mr. Chairman, that these are not all tribal members of tribes. In some of these businesses, 75% of the workers are not members of the tribe. This bill would overturn the National Labor Relations Board's current San Manuel standard, which was issued under a Republican president and established an even-handed approach to balance tribal sovereignty while ensuring workers' rights to organize and collectively bargain and protect that right. The board's common-sense approach relied on long-standing legal precedents regarding when and how federal laws of general application will apply to Indian tribes. These precedents set forth ground rules that require the federal government to withhold jurisdiction if the law interferes with tribal rights of self-governments in purely intramural matters, abrogates rights guaranteed by treaty, or is contrary to congressional intent where Congress indicated that a law should not apply to Indian tribes. The NLRB went a step further to create a fourth exception where there are policy reasons not to assert jurisdiction given the unique circumstances of the tribal enterprise and the impact of asserting NLRB jurisdiction in that case. The board's San Manuel standard has been tested multiple times and been upheld in every court that considered its framework, and furthermore, the Supreme Court has previously declined to review two challenges from Michigan tribal casinos. An argument made regarding this unique issue is that tribes should have parity with state and local governments, which are exempted from the NLRA. However, matters involving tribal self-governance are already exempted from coverage under the San Manuel decision. Courts have distinguished between intramural government matters and tribal casinos, which are commercial enterprises serving predominantly non-tribal clients and hiring predominantly non-tribal members to operate them. Additionally, the claim the tribes should be treated the same as state or local governments is somewhat selective, as Title VII of the Civil Rights Act applies to state and local governments, but Title VII exempts tribes. Some interests have been working diligently to weaken the right of workers to band together and bargain for a better life, as evidenced by the Republican agenda for decades, instead of making a good faith effort to weigh the principle of tribal sovereignty against workers' rights to organize and collectively bargain. This bill would be one of the most significant rollbacks of worker rights in nearly 80 years, impacting hundreds of thousands of workers. We ought to be focused on balancing the two important principles impacted by the bill, but not simply stripping workers of their rights to secure better wages and benefits.